My lord, that's the housekeeping issue.
You've done your bit to save the trees.
To save the trees, my lord. Yeah. Then, my lord, the second housekeeping issue is that effectively we divide the matter into three what I'd call headings. Of course, each heading will have its own subheadings, but I'll explain that, my lord. And the purpose of doing that is that the so-called big headings are the preliminary issues, let's call it the statutory infringement issues, Section 34 of the Trademarks Act, and then the common law issues, which is the passing off. And the reason why I'm explaining that categorization, my lord, is because the passing off section, which is the common law section, is going to be argued by my learned friend, Mr. Skakane, SC. So I'll deal with the two, what I call the two broad headings. My lord, I'm glad your lordship has got the judgment that was passed down yesterday, because I'll be referring to it again in broad terms. And if your lordship allows me, because of the time constraints, when I refer to the cases, your lordship has assured us that your lordship has read the papers, and I know that your lordship is also familiar with the cases. I'll paraphrase. I won't go and read a specific paragraph in order to save time. But all I can say, my lord, is that the case that's presented here is far worse than the case that was presented in the Electoral Court last week. And I'll explain that in some great detail. And it has actually induced me, my lord, to start at what is normally the end of the case, about abuse of process and costs and all that. Normally, as your lordship knows, we do that at the end. But I would request your lordship and implore your lordship to listen to our presentation, both mine and my learned friends, against the backdrop of the serious allegation we make that these proceedings are once again an abuse of the court process and should be visited with a punitive costs order. Because, my lord, this has to stop somewhere. We cannot have our courts being abused in this manner every week in, week out to achieve political ends. But let me put that. I just wanted to use that as a backdrop. On a more legal, strictly legal or constitutional point, I would also implore your lordship to listen to our presentations against the backdrop of the rights contained in Section 19 of the Constitution of the Republic of South Africa. Because, my lord, whatever creativity, and I say that generously to my learned friends, whatever creativity, this matter is about the political contestation and about the exercise of the political rights set out in Section 19. And again, in the spirit of paraphrasing, my lord, your lordship will find that we summarize those rights sorry, in our heads of argument in the introduction, my lord. At paragraph 3. Well, starting at paragraph 2, we say the ineluctable conclusion is that the real and sole purpose of this application is to obfuscate all the issues, cause frustration, and prevent the inevitable. The entire application is devoid of any legal basis which the ANC can sustain to derail the latest political developments brought about by the formation and registration of the MK party as a political party. In this application, the applicant deliberately sacrifices both the law and history in order to urgently satisfy parochial political gains at the expense of the constitutional rights of South African citizens. Section 19 of the Constitution guarantees every citizen the freedom to make political choices, which includes the right to form a political party, to participate in the activities of or recruit members for a political party, and to campaign for a political party or cause. This is the backdrop against which this application should be seen. Now, Your Lordship quite appropriately observed that the case that we are now being told here has evolved somewhat. And it has evolved for the following reason, my lord. You are now told that we are no longer dealing with voter confusion in the voting booth. And that is because my learned friends, again, I can give them credit for good lawyering, but not for consistency. My learned friends, when Your Lordship made the inquiry to say, I would like to be provided with a copy of the MK party logo and the ANC party logo, a point that we are going to make very, very vociferously, then the flashlights came to them. That actually, what we have here, particularly in the passing of case, which my learned friend will deal with, is a bizarre situation where the ANC, with its own logo, with a spear that's facing upwards, since we are going to talk about spears, brings a case to this court on the basis that there will be voter confusion to a voter in the booth between that logo, the famous logo with the wheel and the upward facing spear, and the logo of the MK party. That was the case that was brought before Your Lordship. But because of the remarks made by Your Lordship, now it's shifting before our very own eyes. And just for good reference, my lord, and I just want, again, this is what I call the backdrop kind of discussion. I'll refer Your Lordship to page 13, paragraph 21 of the founding affidavit of Mr. Mbalula. Yes. Is Your Lordship there? Yes, my lord. You see, my lord, there it's made very clear. This case we had this morning is not the case we came here to meet. It says there is overwhelming public interest in ensuring that when voters approach the voting booth, they are not confused as to the party which they are placing their trust in. In the voting booth. In other words, Your Lordship hit the nail in the head in requiring to be given this, because that's what we're brought here to do. This whole case, my lord, is anchored on something called voter confusion. Right? So, yes, the law talks about confusion in general terms. But this case here is not about confusion in general terms. It's about voter confusion specifically. And that phrase doesn't come from us, it comes from Mr. Mbalula, because he goes in to say, it is a matter of clear public interest that any voter confusion caused by the unauthorized use of the ANC's intellectual property is clarified before the elections take place. It is therefore for the benefit of all parties and so on. So the ANC, with its own eyes open, has circumscribed this case to be about voter confusion. That's the next backdrop. I'm not going to elaborate because I want to go to the issue of the preliminary points. Because this is crucial, my lord. to the question of jurisdiction. By the way, my lord, we're in the urgent court, and we've been brought here as a matter of urgency. But my learned friends don't even have the courtesy to tell the court why the matter is urgent. But this is in a matter, my lord, where on their own version they became aware of the events, or should have been aware of these events, to be generous, by the 9th of June. Remember, my lord, that Mr. Mbalula says that he knew or heard about the formation of Mkhonto weSizwe in May of 2023. He then explains, or it is explained in the, I think the DSG explains in the replying affidavit, that it was a rumor mill. So that's fine. I'll give him that credit, that we cannot hold him responsible for what was being rumored, because at that stage you couldn't even attach a logo or whatever to it. Fair enough. But the story of this matter, my lord, legally speaking, starts on the 1st of June 2023. There is no longer a rumor. The MK party applies for registration. On the 9th of June, my lord, that is gazetted. Right? Now, in law, once it's gazetted, the whole purpose of gazetting is that then we are all assumed to know about it, particularly other political parties. Then they don't object, my lord, to that. That's the important trigger. So an application is brought on the 7th, or rather on the 9th of January, 6 months later, and your lordship is not favored with any explanation as to why it's urgent. Remember, if it was brought at that time, it could have even been heard last year, which is the one of the tests for urgency, that could the matter have been heard in due course. But this is a point not just about urgency, my lord, but about the real reason we're here. We're here really to cover up the ineptitude, and I think that's the word that was used by the court yesterday, the ineptitude of the ANC itself, and particularly its Office of the Secretary General. Because it's their duty to object, let's say from the 9th plus 14, 25, 26 of June, what we know as Freedom Charter. That's when they should have objected. As luck would have it, my lord, there was some, your lordship will know from Bundle B, there was some problem. They put 2 logos or whatever. And then the IEC said, no, you must fix this issue. So on the 30th of June, they fixed the issue, and then they re-gazetted, now with 1 logo. So this was just manna from heaven for the ANC. Because now there's re-gazetting, you have a new 14 days. You've missed the first one. They missed the second 14 days. They did not object by the 14th, 15th of July. Then, my lord, on the 7th, the rest we know from the judgment of yesterday. But on the 7th, then the party gets registered, right? This time they already know these people have infringed our trademark. They've actually infringed it twice in their gazetting. In the first time, they infringed our alleged trademark by even twice by putting 2 logos, and now they've done it again. Nothing. They don't come to this court. They say to your lordship, no, this court has exclusive jurisdiction on this matter. Which means at that stage, once they had realized the infringement, then the matter should have been triggered. But here's and let's again be generous, my lord, and say that at that stage they did not even have the trademark, as we know, because the trademark was only assigned in September, right? Fair enough. But what they did do before the effective date of that assignment, assuming it's valid for the purposes of this argument, is they take they do the right thing, by the way, by invoking the provisions of Section 16 of the Electoral Act and complain about the infringement of the trademark and the passing off. Your Lordship, again, with the greatest respect, hit the nail on the head in questioning my learned friend, Mr. Ramokhale. Because Mr. Ramokhale, with respect, tells about Coca-Cola. This has nothing to do with Coca-Cola. When we talk jurisdiction, your Lordship knows from Taba, the leading case on jurisdiction, paragraph 75 of Taba, it says pleadings, or rather jurisdiction must be judged according to the pleadings. So these pleadings don't have Coca-Cola. These pleadings have two political parties, the African National Congress versus the MK Party. So you cannot be told, my lord, that shall we call it, the species of infringement, which is between two political parties, which has been carved out by the legislature, by Parliament, not by your Lordship, not by the courts. Parliament, in its wisdom, decides that when it comes to the infringement of marks, trademarks, that are between political parties inter se, then that is an electoral matter. Sorry, my lord. Thank you, my lord. My lord, I'm deliberately putting these points in tandem because they are related. On the one hand, I'm addressing your Lordship about the agency, the evolution of the matter, but I'm also dealing with the issue of jurisdiction. So, on the issue of agency, my lord, just to finish that litany of failures. When now the ANC on its version has now acquired the trademark, instead of coming to this court, they go to the commission with an appeal. And your Lordship's question in regard to that was not answered because your Lordship was asking whether the matter could have been reviewed, and then you referred to an appeal, which is a different thing altogether, but let's put that aside. So the appeal is then dismissed. That, in terms of the Act, your Lordship knows you have 30 days to then do something about it. 30 days expires on the 24th of December, Christmas Eve. They do nothing. And that has serious legal consequences to these issues of abandonment and election and so on, which I'll talk about in relation to jurisdiction. And it's clear that the real trigger, and in this case, unlike in Bloemfontein, at least there's a bit of honesty, that the real trigger is what they call the so-called utterances, which were accompanied by the announcement of former President Jacob Zuma on the 16th of December. And then they wake up and then they bring this matter. So, my lord, there's no explanation whatsoever for the 6 months of doing nothing. So, on that basis alone, and given the fact that our learned friends chose not to address that issue, then it has to be ruled in our favor. But let's come back now to this issue of jurisdiction. which is, in fact, my lord, in fairness, the issue of jurisdiction is a primary issue. Because if your lordship, we know the cases, if your lordship doesn't have jurisdiction, then in theory you can't decide anything else. But of course, our courts, like they did yesterday, because the thing might go on appeal, they do address the other issues. But strictly speaking, once the court has no jurisdiction, that's the end. We all go home, because it means the court cannot decide any other issue, whether agency or whatever it is, beyond that. But anyway, so let's deal with that issue. My learned friend, Mr. Ramokhala, my lord, I'm quite sure was not intending to mislead the court, but you are only as good as your case, and the case he has is unfortunately untenable. If your lordship goes to page 48 of bundle A, bundle B, my lord. Your lordship will see a more explicit, your lordship referred, my learned friend, to paragraph 66.2. But your lordship will find a more explicit reference, which is why the reference was made to that 66.2. Sorry. If your lordship goes to page 48, annexure FA6, this is the appeal, let's call it, the appeal complaint of Mr. Mbalula to the commission. This is against the backdrop that we are now told all of a sudden, when they realize they have a jurisdiction problem, that this case has got nothing to do with the other two cases, or those cases had nothing to do with trademarks complaints. But your lordship, go to page 49 at the top. Mr. Mbalula says, the distinguishing mark or symbol of Umkhonto weSizwe Party, as it appears in Annexure B, has been registered in terms of Section 29(2) of the Trademarks Act 1983. That's wrong, that should be 1993, but that's fine. 49, my lord, at the top, the top of 49. Yes, yes, thank you, my lord. Yeah. And it says, has been registered in terms of what they say has nothing to do now all of a sudden. Section 29(2) of the Trademarks Act of 1993, it should say there, with effect from 20th August 2014 for a period of 10 years by the MK Legacy Project. That's another misrepresentation. There's nothing called the MK Legacy Project. It's a legacy project, but they are just embellishing it. Yeah. But we'll come to that. A non-profit organization devoted to the preservation of heritage of the liberation movement, including Umkhonto weSizwe, the People's Army, and so on and so on. The certificate of registration is attached. And then, if you go further down that page, my lord, you'll see, it says, accordingly, for these reasons set out above, if your lordship underlines that, the ANC appeals to the Electoral Commission in terms of 16(2) and 3 of the Electoral Commission Act to set aside the decision of the CEO to register Umkhonto weSizwe as a political party. Now, what are the legal implications of that, my lord? It is that, according to Mr. Mbalula, his appeal to the commission was squarely on the basis of the Trademarks Act, the provisions of the Trademarks Act, or at least the alleged infringement thereof. And this goes to a fundamental mistake, my lord, which is insurmountable, that my learned friends make in, shall we call, characterizing our objection about jurisdiction. Our objection about jurisdiction, my lord, they say glibly that, no, we got it all wrong. We are confusing this case with the case in Bloemfontein. No. It's a triangle of proceedings. There's the case in Bloemfontein, there's the case here in Durban, and there's the case before the commission that they raised before the commission. Let's call it the case in Pretoria. I know that it was not in a court, but it was in the commission. But I'm using this as an issue of illustration. So when we talk about you have approached another forum, and now and then you abandon proceedings in that forum, and then you come here. We're not talking about Bloemfontein. We're talking about Pretoria. So we're saying you correctly pursued your remedies in the forum, in the commission. You lost that case. It was dismissed on the 24th of November. And then instead of doing what your lordship was alluding to, which is either to appeal or to review that matter in terms of Section 20. And my own, I was also under the impression that the only remedy which should have been available to them, my lord, would be the appeal in Section 22A. But one of my learned juniors, Miss May, pointed out that actually they also had the right to review that decision. So they actually had two remedies. Your lordship knows the difference between appeal and review. So if they thought it's irregular, they could have reviewed it under 21A. But if they thought it's incorrect, if they don't agree with it, they could have appealed it under Section 22A. But for the purposes of this discussion, that doesn't really matter. What matters is that their remedy of whichever type lay in the electoral, let's call it the electoral commission system, which would have led them to the electoral court. You see, jurisdiction cannot be determined by this kind of approach of saying, no, the matter didn't reach the electoral court. Therefore, that court did not have jurisdiction. It doesn't work that way. The fact that you abandoned your right to appeal, let's say in the tax court or whatever it is, it doesn't mean that that court now suddenly loses jurisdiction. It's your election. In other words, to put it bluntly, you are in the same position as somebody who did exercise that right and lost. So this kind of shortcut doesn't work. The point we're making is not that the matter was taken to the electoral court. We know it wasn't. But we're saying that's the only place it could have been taken after losing that appeal, either by way of appeal, as my learned friend pointed out, or by way of review.
As I understand the case for the ANC,
yes, my lord.
the contention is that the appeal against the registration of the MK party was persisted to the electoral court, and that resulted in the court's judgment yesterday.
No, my lord. The review.
Yes, yes. So in terms of which it was contended that the deputy CEO irregularly authorized
the registration.
Insofar as its argument pertaining to trademarks, if I understand Mr. Marriott correctly, he contends that that was reserved for this court on the basis that only this court, as a division of the High Court, has jurisdiction in terms of trademarks.
Yes.
I'm just
No,
encapsulating what they
your
are.
lordship is 100% correct. That is their case. But let me illustrate the flaws in that argument, my lord. According to the Constitutional Court decisions in Chirwa and Gaba, the lordship knows very well that what those courts said was that where a specialist court has been designed to deal with a particular area of law, then that mechanism at all levels must be followed. So when they make that submission, my lord, they are wrong on two fronts. We are not quibbling with the case, and my learned friend Mr. Ramkhal is quite correct. The case about the registration or non-registration by the DCEO and so on, that was decided yesterday, is water under the bridge. The case we're talking about, my lord, is the one that they did bring before the commission, which was the case of the infringement of the trademark. That's the one I referred your lordship to, page 49. That case they did bring. And that case was then dismissed on the 24th of November, my lord. And it is that case which they had the option by the 30th, in the review, if the review would have had to be done in 3 days. But let's take the best case scenario for the ANC, that by the 30th of December, after 30 days, by the 24th of December, they would have had to appeal.
Can you please give me the reference to the dismissal?
Of the, yes. Your lordship, yes, my lord. Your lordship will find that at bundle A, 58, FA7. Page 58, my lord. That's a letter from the IEC.
Sorry, bundle A.
Bundle B. Sorry, I'm thinking because that case happened before. That bundle B is the Bloemfontein. Okay, I'll use B for Bloemfontein. So bundle B, my lord. Yeah. Page 59, my lord. I beg your lordship's pardon. The letter starts at page 58. So that's the dismissal letter, my lord. But you see, again, this obfuscation is uncanny, because that is a dismissal of a case brought under section 16 of the IEC Act, which your lordship pointed out to my learned friend. It doesn't matter that it was dismissed because there's no locus standi or whatever. The case was dismissed. And what was the case? The case was about the infringement of the trademark. And the dismissal of that case, my lord, attracted the right of the ANC to either review or appeal that decision, which they failed to do, meaning that in legal terms they preempted that appeal and accepted their fate in respect of the infringement proceedings to do with voter confusion. They threw in the towel and said, well, it is what it is. Now, once you do that, once you abandon your appeal, whether by ineptitude or carelessness or whatever it is, you cannot, the doctrine of election is very clear, my lord. You can't then come to this court, just because you lost in the other court next door, and say, court, I'm here now afresh. That is exactly what Makanya says you cannot do. But before we get to Makanya, my lord, let me summarize the position as follows. The ANC on jurisdiction can only succeed if it convinces your lordship that this court has exclusive jurisdiction.
On the issue of the trade.
On the issue of the trade, if I can say this, my lord, on the issue of the trademark pertaining to two political parties leading to voter confusion. Because that's exactly, those words are not mine. They come from Section 16 of the IEC Act. That wherever there is a dispute about trademark and passing off, for that matter, but which pertains to two political parties and will lead to deception or voter confusion, that cause of action has been carved out by the legislature to be administered under the structures of the IEC Act, which end up in the electoral court. It is in that sense that we say that court has exclusive jurisdiction, and the jurisdictions cannot be denuded simply because you decided not to go all the way. So there are three possibilities, my lord, on jurisdiction. It is either this court has exclusive jurisdiction, as they say, or the electoral court has exclusive jurisdiction, as we say. Or, if the court wants to be kind, then the court will say, well, maybe both courts have concurrent jurisdiction. The point I'm making is that the ANC can only succeed on jurisdiction if it can convince this court that this court has exclusive jurisdiction. If it's exclusive jurisdiction or concurrent jurisdiction, then they must lose. And I'll explain the second part. It's obvious if the other court has exclusive jurisdiction, that's obvious, then they must lose. Why am I saying they must also lose even if there's concurrent jurisdiction? My lord, your lordship will, if your lordship goes to our heads, you'll see our reference to Makanya, our page 24. Yes. No, I'm looking for the Makanya quotation.
Yes,
it's page 22, my lord, of the heads, paragraph 54. Bear in mind, my lord, while your lordship is looking for, it's page 22 of our heads, paragraph 54. Your lordship, I would be saying, if the case was in front of you, your lordship must put a finger on the CAM case that your lordship referred to. Yeah. Remember, CAM says is our ground for exclusive jurisdiction. I'll come to that. I'm now dealing with concurrent jurisdiction. Let's say they have concurrent jurisdiction. Then this is what the SCA said in Makanya. Naturally, a claim that falls within the concurrent jurisdiction of both the High Court and the Special Court could not be brought in both courts. That's obvious. A litigant who did that would be confronted in one court by either a plea of lis pendens, the claim is pending, or by a plea of res judicata. It is in that context that we raise res judicata, but I'll come to that. A claimant who has a claim that is capable of being considered by either of the two courts that have concurrent jurisdiction must necessarily choose in which court to pursue the claim, and once having made that election, will not be able to bring the same claim before the other court. Let me pause there, my lord. What this means is that if Mr. Mbalula or the ANC, let's say on the 30th, sometime in December, we're now faced with this choice to say, okay, our claim has been dismissed there. What should we do next? And let's assume the lawyer said, well, you can either go to the High Court or you can go to the Electoral Court under Section 20 of then that lawyer would then be in normal language saying there's concurrent jurisdiction. In the normal course of events, my lord, then they would, if you have concurrent jurisdiction, you can go there or here. But this is not the normal course of events. Here, an election has already been made to pursue that claim under the auspices of the IEC Act, the Commissions Act. And the abandonment thereof becomes irrelevant. This is what the SCA say you can't do. Once an election is made, you will not be able to bring the same claim before the other court. In other words, the High Court. But, and that's the point we make, my lord. And then it says, where a person has two separate claims, each of a different right, and the position is altogether different because both claims will be capable of being pursued simultaneously or sequentially, either both in one court or the other. But remember my earlier submission, my lord, is that here we're actually dealing with the same cause of action.
Well, let us impose it.
Yes, my lord.
Pointed out that a plea of res judicata on these claims would only be able to succeed
If it's a court.
you meet the following requirements. The parties are the same, issue is the same, the court is already pronounced.
Yes. No, that is true, my lord. But again, this is the conceptual shortcomings with my learned friend's argument, because they take our argument literally. In other words, what they are saying, when we say the matter has been decided, we postulate that matter would have been decided. Had they pursued the thing to its logical conclusion, it would have been decided one way or the other in the electoral court. So they can't lift themselves by their own bootstraps by abandoning that process which they were pursuing, and then suddenly say, it has not been decided. That, my lord, would be like a person doing this. A person accepting that in labor relations you must go to the CCMA, and then if you fail, you go to the labor court for a review. Say the party accepts that. But that party, in trying to be too clever, then goes to the CCMA, loses the review there, and then it says, I'm going to the High Court. Then it goes to the High Court, and it says in the High Court what Mr. Ramokhala is saying to your lordship. No, but we never went to the labor court. So we're here now. It doesn't work that way. That court, the labor court, has exclusive jurisdiction of that matter. Whether you went there or not is your own baby. But the court that has the exclusive jurisdiction will remain the labor court. It's exactly the same here, except that the commission, the CCMA, replaced CCMA with IEC. That's all. So that's exactly what they did. They went and pursued those remedies, and when they lost, then they abandoned the remedy, and then they ran to the High Court. You can't do that. That's exactly what Makanya says you can't do.
Are you contending that they should have pursued the matter before the
electoral court?
But herein lies the problem, at least for me.
Yes, my lord.
That the electoral court is a creature of statute.
Correct, my lord.
There's no inherent jurisdiction.
Correct, my lord.
So we know from the Concord that the electoral court's jurisdiction in a wide, expansive sense, as they said in Canada, deals with all matters pertaining to
Electoral matters.
So one-stop shop for electoral disputes.
Correct.
But that being the case, does the electoral court have jurisdiction to deal with a trademark dispute as appears or as defined in terms of the trademark? That's the question.
No, my lord. With the greatest respect, that is not the question. The question, my lord, is has Parliament, in its wisdom, decided, as it did with the Labour Relations Act, to carve out the disputes that concern political parties and lead to voter registration, and transported those out, in a way, out of the Trademarks Act into for the obvious policy reasons. Your lordship knows these things must be done fast by people who are specialists and so on and so on. And for those reasons, carved it out for the special attention of the specialist court. And the answer to that question, my lord, is a resounding yes. And it's a resounding yes, fortified by what was said, and your Lordship just preempted me to go to the CAM decision. And I'll quote it, paragraph 40, my Lord, I'll quote it also just for convenience, as it is reflected in our heads at paragraph 58. And there the Constitutional Court says the following: relation to the jurisdiction of the Electoral Court. Is there anything in the context that would warrant a more restrictive interpretation of the section and hence the Electoral Court's jurisdiction? In other words, should we take away from the jurisdiction of the Electoral Court that which has clearly been given to it? I think not. The clear purpose, and we know that we use purposive interpretation, the clear purpose was to establish a court that would be able to deal with all electoral matters, the point your Lordship just made. It was constituted with the same status as the High Court and with the judge of the Supreme Court of Appeal as its chairperson. It is to resolve electoral disputes as a matter of urgency. That's the policy reason. There is not the slightest indication that the intention was to limit the range of disputes that would fall within the ambit of the Electoral Court's jurisdiction, so that some electoral issues would fall within its jurisdictions and some not. Instead, the breadth of the language used suggests that the statutory purpose was to create a specialist court that would deal with all electoral matters, again, all electoral matters. And our jurisprudence holds that when a specialist court is created, the apparent purpose of creating a single forum for resolving disputes of a particular type is not to be stultified by a resort to undue literalism and too careful a passing of statutory language, as my learned friends are doing. That is so the combination now between CAM and what was said in Makanya. So, my Lord, yes, your Lordship's question is with the greatest respect, should be asked in the opposite. That what was the purpose, my Lord, of putting a section like Section 16 of the IEC Act? The purpose could only have been to carve out, to isolate, to say, okay, we have the Trademarks Act, but in this area of where we're dealing with voter education, voter confusion and so on, where you infringe a mark in that context, then, as your Lordship pointed out, the CEO can even reject your application, because that area is where it's political party, not Coca-Cola. If it was Coca-Cola, yes, of course, my learned friend is quite correct. Then they are at large to in fact, the Electoral Court would have no jurisdiction in that dispute of Coca-Cola. So, my Lord, that's really the issue on jurisdiction. This court, whether it has exclusive or concurrent jurisdiction, if it has exclusive jurisdiction, then the matter must be dismissed on that basis. If it has concurrent jurisdiction, then it must be dismissed on the basis that an election has been made, which cannot be avoided, a la Nugent J.A. in Macan. That would then, if life was so simple, I would then sit down, my Lord, and say, well, your Lordship can't deal with any other issue, but unfortunately it's not like that. The issue of urgency I've already addressed. This then takes us to the other serious issue, my Lord, which is brushed aside again by my learned friends, the issue of locus standi. You'll find, my Lord, that locus standi is not even dealt with in their heads. But I think it's paragraph 12 of their heads. Where they, yes, 12. They redefine the issues and just decide to take off. They say, we'll deal with the points in limine. First, we dispose of the points in limine raised by the first respondent relating to the court's jurisdiction, res judicata, and non-joinder, all of which are make weight and dealt with comprehensively in reply. And then they deal with with them in one paragraph, in one quick paragraph. They don't even talk about locus standi. But my Lord, locus standi is actually a bigger problem for them than even jurisdiction, with the greatest respect. Because we don't have time, my Lord, I'm not going to deal with the contra bonus mores. We're not abandoning that argument, my Lord. Safe to say that it surely cannot be correct that the only time a court of law can assail a contract is when you attack the constitutionality of that. A court is obviously at large to make a finding that two parties are here to enforce a contract, but this contract is contra bonus mores and unenforceable, and therefore I will not enforce it. So it's in that context that we say it's contra bonus mores. And we say that because, my Lord, really one would have to be extremely, deranged to think that the ANC, such a serious organization, went and did this assignment for the purpose of trademark protection. It can't be, my Lord. Why would the ANC go and buy, for an undisclosed amount, assignment of a trademark that, as we speak now, is left with 1 month? It's going to expire now in June. It's been there for 10 years. For 9 years, it was fine. Legacy projects could do whatever they wanted. MK gets registered. Boom. They now suddenly have an interest to pay money to... Please. My Lord, the clear intention, the ulterior purpose was to circumvent the political rights of the MK party and its fortunes in the forthcoming election. That is patently clear. Nobody has suggested otherwise. But, as I say, my Lord, the ulterior motives aside, let's say the ANC had a jolt of, philanthropic fervor to protect trademarks in general. Then they have this problem, this secondary problem to do with locus standi, my Lord. It is established, my Lord, that for you to have locus standi, we're now playing along with them. We're saying this is purely a trademarks matter, nothing to do with elections or voters or whatever. It's Coca-Cola. So, to assert that trademarks, your Lordship knows, the only title you need is to be a registered proprietor. Sorry, my Lord. Your Lordship just bears with me. Your Lordship will find that at paragraph 12.4 of website page. Which is on page 12-7. And just out of interest, your Lordship will also find the same proposition in EMLA, the book written by Arams under trademarks. So, Arams J.A., even though he was not writing in that capacity. Makes the same point, and in LOSA, by the way, but I don't count LOSA because LOSA looks like that section was also written by Webster. So that would be double counting. But here's the section, my Lord. Your Lordship has got LOSA. You'll find that in the section on infringements, the heading is probably "Who may sue for infringement?" Sorry, my lord. Yes, it's paragraph 220, my lord, of LOSA. If your lordship has got the latest 2023 version.
Not as lucky as you.
I know, my lord, sorry. Some of us have
Yes.
the latest. Okay, but then, my lord, you'll find it under the, it says infringement general.
Yes.
Then it's 1, 2, 3 paragraphs later.
Very well.
Yes. It says, I'll read that one just because your lordship has got it here. But as I said, it's clearly been written by the same person. It says, an action for infringement lies at the instance not only of the registered proprietor. Underline those words, my lord. Registered proprietor, not just the proprietor of the mark infringed, but also under certain circumstances at the suit of a registered user. That's not relevant for the current purposes. And then it says in Dantex, it has formally called for proprietor. No, it doesn't matter. A mere agent who has not registered in the mark, however, has no locus standi to sue for infringement. But the point I simply want to make, my lord, is both Harams and LOSA say that you must be the registered proprietor. I don't understand my learned friends to quibble with that trite proposition of trademarks law. Now, the question then, my lord, again, on which I should just sit down, is if the answer to the question, who is the registered proprietor of the mark? Or let me put it this way, my lord. Unless the answer to the question, who is the registered proprietor, is the ANC, then we should all go home. Because that's the only person who can bring a trademarks infringement claim under Section 34. So,
I think it's 34.3.
34, in 34.3, yes. 34.3 of the Act, as the court pleases, my lord. Yeah. Now, here's the thing, my lord. This is the most bizarre part of this case. Now, so the ANC wants us to believe the following, that merely by entering the assignment agreement, the bilateral agreement, the private agreement or private arrangement between it and Legacy Project, it suddenly became the registered proprietor. Even the ANC knows that that is false. Because, as your lordship knows, even with registration of land and so on, in fact, my learned junior, Mr. Shai, made this example, that if you can qualify and pass the exam, but that doesn't mean you have the certificate, the degree. You are not registered in that university simply because you have passed. And you can be an advocate and all sorts of things, yeah. But more closer to home, your lordship knows the system of registration of land rights. So I can buy a piece of land from my learned friend, Mr. Ramokhale, and we have our agreement. But that would not give him the locus standi, or sorry, me, the one who bought. It wouldn't give me the locus standi to go and do a re vindicatio. Because who's the registered owner? It's him, until such time that the registration has happened. Same thing here, my lord. The mere fact that these parties have entered into an assignment, assuming it's valid for the purposes of this argument, does not imbue the ANC with the right of the registered proprietor. The registered proprietor remains Legacy Projects. And that even touches, my lord, if I may, on the issue of non-joinder. So you come to court and you don't join the registered proprietor, for the time being at least. and you say you must succeed. But my lord, here, there are few cases where there's the so-called smoking gun. But here's the smoking gun. If I take your lordship to page 256 of bundle A, the real bundle A this time. This document, my lord, sorry, my lord. Two, 5, 6, my lord. I hope that's the correct. Just check. It's the application for. Yes, it is 256, my lord. Yeah. Yes. My lord.
That's the name of Legacy Projects.
NPO. Yes.
The ANC.
Yes, my lord. We'll organize your lordship to get a proper copy. I'll ask my learned friends. This is a very important document, my lord. Your lordship has to get a proper copy of this. Let me tell you what it says, my lord. This is the ANC itself. This is an application to record a transaction affecting the rights of assignment and transmission and so on. So this document spells two serious problems. My lord, yes, I beg leave to hand up. I'm indebted to my learned friend. My learned friends have just supplied me with a more legible copy. Thank you, my lord. So this document poses two serious problems for the ANC, my lord. Firstly, it is signed on the 15th of January, as your lordship will see at the bottom. 15th January 2024. That means a week after these proceedings have been instituted. And they claim that on the 9th of January, they were the registered proprietor, right? But on the 15th of January, this is what they say. The form says to them, Section 40 form, full name of existing applicant, proprietor, assigner, and business address. Who do they put? Legacy Projects. And then it says the full name of proposed applicant, assignee, or business address. Who do they put? African National Congress. So this is their document, their own application. In their own formal application, they know when the truth has to come out who the proprietor is. That is Legacy Project. And they're right. Because until such time that the assignment has been registered, as the examples are made with the land and so on, they are the proposed registered proprietor.
So in the case of land, you know the registration of land, that's the date of registration.
Yes, of the yes.
That rights passed.
Yes.
In terms of this document, what then is the import of the effective date which appears here as 23rd?
Yeah, there are two imports for that, my lord. Firstly, let me make the prior point I was making. The prior point is that, my lord, the African National Congress, the applicant before you, when asked who is the proprietor, they identify Legacy Projects. That's the first point. The second point, then, my lord, is your lordship's issue about the effective date. You see, that answers that question can only arise if their assumption that the mere entering of the assignment and its effective date imbues them with the title of registered proprietor. That's wrong. But let's entertain it for now. Let's say it does. If it does, my lord, then they run into a second cul-de-sac, which is this. If the effective date of the assignment is the 23rd of September, then how can they come before your lordship and say they are complaining about the infringement of trademarks by the MK party, which happened in June 2023, and August, and at West in September 7th, on the 7th? They can't. Because even on that version, which is wrong, by the way, even on that version, they are non-suited from a point of view of locus standi, because at that stage they had not acquired. Your lordship knows that the assignment of rights, and this is right, cannot operate retrospectively, particularly vis-a-vis third parties. So as between the parties, if they wanted, my lord, themselves, they could legislate, because it's their own contract. So they could say it will operate retrospectively between us as parties. But that can never be the effect of an assignment, any assignment of rights vis-a-vis innocent third parties. That would be a serious abrogation of the law. Thank you, my lord. And my lord, you'll find that in Webster 11.16. Sorry, yes. Webster 11.16. Yes, my lord.
Insofar as the objection to the symbol registered by the MK party,
Yes, my lord.
seems to have read in humble fee that was objected to by legacy projects.
No.
I have that wrong?
No. Yes, my lord, you do. What happened, your lordship, if you go to bundle B, you'll find that in the remember, I just took your lordship to page 48, which was the letter of Mr. Mbalula. Now, if you look at the annexures to that letter, my lord,
There's Annexure E.
yes,
55.
absolutely.
That's what I'm looking at.
Yes. Annexure E, there was no objection by legacy projects, my lord. What happened is that Mr. Mbalula, obviously in collusion with legacy projects, attached to his letter that we just read earlier at page 48, two things, among others. One was a letter by the so-called MK Light, it's called MK, I forgot its program. Umkhonto Wesizwe Liberation War Veterans. That's what we'll find on page 57. Then there's the letter that your lordship is talking about, legacy projects at page 55. Yes, it's merely, my lord. It's not an objection per se. It's merely an annexure to Mr. Mbalula's is evidence. Let's call it that. It's evidence that he seeks to bring to the attention of the IEC that these people, and all it says, my lord, quite frankly, it doesn't say anything except to say that it reiterates the Section 29(2) of the Trademarks Act and so on.
Yes,
So,
Mr. Importer,
yes,
the letter is addressed to the chairperson of the Electoral Commission.
yes, my lord.
And it says that it reads as follows: we were shocked and dismayed to learn that a political party has been registered using the names and symbols of the Congress state. We submit that using the symbol, the name, that it seeks to be associated with the violation of the above intellectual property rights. This date is written on the 20th of September,
Correct.
2020,
Yes.
which is 3 days before the signing
Yes.
between itself and
Correct.
the ANC.
Yes.
But what my reason for raising this is, all I wanted to establish was what became of this objection. Do you?
No, my lord, because and I can just explain what happened. Remember, my lord, that imagine if the IEC found that the ANC, which is a registered political party, has no locus standi in this particular case to make that objection. Then a fortiori, Legacy Project, which is not even a registered political party, could never have such a locus standi, because the acquisition of the locus standi in that is by you having been an objector, which they have failed to do, and then you now. So that is why they got proper advice that legacy projects cannot put such an objection. It can only come in the form of evidence as an annexure to Mr. Mbalula's letter. So there was no objection, with the greatest respect, by either MK something, Liberation War veterans, or the legacy project. But even if there was, my lord, actually it's a case. It would then be a case against them, because it would show that the true proprietor, as at the 20th. So if this objection, my lord, was not done in the context of the Electoral Act, let's say it was done in the Coca-Cola example, then Legacy Project would have been perfectly entitled to come to the registrar of trademarks and say, we just saw that there's somebody who's abusing our trademark. They didn't do so. So somebody who was not on the 20th, let's just use the 20th as an illustrative date, yeah. How can the ANC come to you, my lord, with its, with a straight face and say that we are coming to assert the trademark rights, which on our own annexure, as at the 20th of September, were vested in legacy projects? And Nochal were not going to even join those people, even though they actually they would have been the correct plaintiff, at least for that period.
Now, according to my watch, or 5 past 1,
Yes, ma'am.
according to my watch, your team has another
25.
25, 28 minutes left. You can decide between yourself and Mr. Skakane how you wish to divide that time.
Yes.
I'll take the adjournment now and return at 2 o'clock, and then hear the remainder of your
As the court pleases, we thought at least would be given the same as the other side.
Yes.
They went over by 8 minutes, I think. But it's fine. All right, my lord. My Lord, yes. When we come back, what I will do actually is I'll use up, so to speak, that credit just to round off, and then Mr. Skakane has assured me that from what he has heard, he doesn't need much more than 25 minutes.
You've got a set period of time, as I indicated.
Yes, my Lord. No. That we understand.
And I'll hold you to.
Yes, my Lord. My Lord, then what I'll do, if your Lordship can just let me, then just give me literally 1 minute, my Lord, because I just want to round off so that I start on something else. So, my Lord, what we're saying on locus standi is a simple submission, which is that the primary one is that the ANC, even now as we speak, is not the registered proprietor. But the generous one is that for some reason, on the 23rd, let's say it became a registered proprietor. Even on that generous interpretation, my Lord, it would not have the locus standi to assert the rights which were infringed on the 7th of September or any time earlier. And therefore, for that reason alone, my Lord, the ANC has no standing before this court on the statutory claim. As a court businessman.
All right.
Well, what are we going to do?
Let's see when if I have 20 minutes.